This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why denying a letter seeking an arson fire is fraud and why it never pays to lie to your insurer, because if you do, you will lose. Soliciting arson is and always will be a criminal act that is part and parcel of an insurance for-profit scheme that is a crime. Plaintiffs Richard Converse and Stephanie Converse own a piece of real property. Defendant State Farm Fire and Casualty Company insured the property at all the relevant times, and after a fire on December 8, 2019, plaintiffs sought coverage under the insurance policy. Plaintiffs brought this action when Defendant State Farm denied coverage for much of the claim. In Converse v. State Farm, a July 12, 2023 decision of the United States District Court for the Northern District of New York, the district court was asked to rule on cross motions for summary judgment. State Farm insured the Converses against the risk of loss to a rental property under a homeowner's policy. The parties agree that Plaintiff Stephanie Converse sent a letter to Joseph Pelton on or about November 8, 2019 that stated, quote, "Joe, having issues with my house again, need help this time. I will pay $5,000 cash when I get the insurance. The back door will be unlocked and open to the basement. That's where the access to utilities are. Make look like electrical. I will come up after it happens, so I will meet up with you. It's a mint green house with a garage. Love you. See you soon, Stephanie." Close quote. While plaintiffs admit that Stephanie Converse mailed the letter, they deny any implication or allegation that Stephanie Converse committed insurance fraud, paid anyone to commit arson on the property, or was in any way involved in the fire that caused the loss to the property. Stephanie Converse filed a claim on December 8, 2019 for the loss caused by the fire. State Farm mailed Stephanie Converse a blank sworn statement and proof of loss and return envelope. The cover letter stated that the sworn statement should be returned by February 17, 2020. State Farm counsel Roy Moura reminded Stephanie Converse that she had to return the sworn statement, and the letter warned that a failure to timely complete and return the sworn statement and proof of loss form for the reported loss may result in loss of your rights under the policy. Stephanie Converse appeared for an examination under oath in connection with her insurance claim on March 13, 2020. Stephanie Converse affirmed during the examination that everything, as far as she could recall, was truthful about what she told Mr. Lorca, the State Farm adjuster. Converse further testified that she could not recall asking anyone to burn. I can't remember. I don't know if I did or I didn't. She further testified she could not recall whether she had offered to pay anybody money to burn the property down. Defendant, with good reason, denied Stephanie Converse's claim on October 7, 2020, and plaintiff sued. Defendant first argued that State Farm has no obligation to provide coverage under the policy because Converse breached the insurance contract by making material misrepresentations in reference to her claim. The materiality requirement is satisfied if the false statement concerns a subject relevant and germane to the insurer's investigation as it was then proceeding. Plaintiffs deny that Stephanie Converse willfully made any material misrepresentation. Defendant does not argue, however, the plaintiff dissembled about the cause of the fire at the home, committed arson herself, or paid Joseph Pelton to set the house on fire. The court found that as a matter of law, plaintiff made these misrepresentations willfully. Taken as a whole, the court concluded that Plaintiff Stephanie Converse's statements represented a continuing attempt to conceal from State Farm that she had contacted Pelton and offered him money to burn down the insured property. The court concluded that a reasonable juror could not find that such contradictory statements were the results of mistake or misunderstanding, but that the differences between what plaintiff told various investigators were intentional. The purpose of procedures like an examination under oath and other investigative measures is to enable the insurance company to acquire knowledge or information that may aid it in its further investigation or that may otherwise be significant to the company in determining its liability under the policy and the position it should take with respect to the claim. A reasonable juror could only find that her misleading conduct was material. Stephanie Converse made material misrepresentations to insurance investigators as a matter of law and breached the insurance contract, and defendant was entitled to summary judgment in this respect. In addition, testifying falsely can also breach the condition of cooperation, and Stephanie Converse admitted to the Lee County Sheriff's Office investigators that she had written the letter she had denied to State Farm. Converse thus made misrepresentations about facts material to State Farm's investigation. Given the inconsistencies in Stephanie Converse's stories to various parties, and her clear misrepresentation to State Farm about her knowledge of the letter to Pelton, no reasonable juror could find that Converse's misrepresentations were not willful, and therefore violated the contract in the meaning and opinion of the trial court. And in addition, when an insurer gives an insured written notice of its desire that proof of loss under a policy of fire insurance be furnished, and provides a suitable form for such proof, failure of the insured to file proof of loss within 60 days after receipt of such notice or within any longer period specified in the notice is an absolute defense to an action on the policy. There is no dispute that plaintiff did not return a sworn statement in proof of loss until March 12, 2020, well after the date specified by State Farm in correspondence to Converse. Defendants, therefore, has an absolute defense to plaintiff's claims, and its motion for summary judgment was granted, and plaintiff's motion for summary judgment was denied. In my opinion, an insured who seeks to hire a person to set fire to her house for a fee paid for insurance proceeds is offering to pay for a felonious act, sometimes called arson for profit. If the person refuses to set the fire, has an alibi when the arson fire actually occurred, performed by a person unknown, and the insured lies about her offer to burn her house, the lie is sufficient to deny the claim in accordance with the terms and conditions of the policy. So the case proved that the old saw that liars never prosper is still true. In addition, State Farm could have simply denied the claim for failure to file a proof of loss within the time required, and would have won on that issue alone, and it could have denied the claim for the failure to cooperate, and it would have won again. So it won 3 different ways, and Ms. Converse and her brother received nothing from the arson fire, even though no one was arrested, no one was tried, and no one was convicted for setting fire to the house. This video was adapted from my blog, Alma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you will receive notice of every new blog postings, usually 5, sometimes 6 a week. And you will also receive access to all 4,550 or more blog postings. If you found this video or the blog posting to be useful, please tell your friends and colleagues about the blog and the videos so that they too can subscribe. You can subscribe to the videos on YouTube or rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And if you wish further detail and knowledge about insurance, insurance claims, and insurance law, may I suggest that you consider, for a very small fee, subscribing to my Substack publications or my Locals community. Thank you for your attention.